right to freedom, and the rights of workers and all marginalized people. He fought against all sorts of authoritarianism, religious fundamentalism, and obscurantism. Also fought against oppression and discrimination of women in all respects. The historic celebrated judgment in Shabanu case, which declared right to maintenance for diverse women, diverse wife, is a monumental, his monumental creation. A milestone in the fight against patriarchy and male chauvinism in the society in the name of religion or otherwise. Of course, this judgment also exposed appeasement of religious fundamentalism and patriarchy by the political executive. His social and ideological commitment to secularism and ethos of the constitution naturally brought him to like-minded radical lawyers. When All India Lawyers Union was formed at the initiative of Justice V.R. Krishnaiyer, Jyoti Basu, and Justice Desai to redeem the constitution, freedom and democracy in the wake of emergency in the year 1983, Sri Daniel Lathifi was elected as his founder president. He was a natural choice. Now, dear friends, India is passing through the darkest period after independence. When there is onslaught on secularism, freedom, and all the ethos of the constitution, we rededicate ourselves to save the constitution and to save democracy. At this juncture, no such fight can be thought of without reference to our judiciary, the great arbiter in our democracy. When the formal democracy is attempting to annihilate secularism and the essence of democracy, judiciary should be the sentinel of the QEV, not a mute spectator. All India Lawyers Union has been fighting and campaigning for an independent constitutional body, National Judicial Commission, with the comprehensive powers for selection and appointment, transfer, and to inquire into misdemeanor of judges of constitutional courts, as the present system is not suitable for protection of the independent judiciary. The recent revelation by former Chief Justice of India, Sri Justice Ranjan Gogoi, in his autobiography, with the reference to transfer of Justice Qureshi, illustrates the weakness of collegium system to protect the independence of judiciary. Dear friends, I am not touching the subject at all. I am sure you are here for hearing the words of our great Chief Justice, Justice Thottathil Radhakrishnan, our chief guest, a great judge, a great humanist. He was acting Chief Justice of a home High Court of Kerala, Chief Justice of combined Andhra Pradesh High Court, Chief Justice of High Court of Telangana, Chief Justice of Chhattisgarh High Court, and retired as Chief Justice of Calcutta High Court. When we thought of this subject for Daniel Lathifi first memorial lecture, the first name came in our mind is Justice Thottathil Radhakrishnan. There was no other choice. Sharing of experience as head of judiciary in various high courts, would definitely benefit us in our right to protect our constitution and democracy. For the democratization of the judiciary and the society, I respectfully and wholeheartedly welcome you, sir, to this function. President of our today's function is not only our president, but also an eminent member of our parliament, Upper House of Parliament, Rajya Sabha. He was also a former mayor of Corporation of Calcutta. He is part of our organization. Still, as president of today's function, I formally welcome you, sir. Advocate Anil K. Chauhan is our national treasurer, a quiet, unassuming leader with simple manners who has been silently organizing lawyers, law teachers, and law students. I wholeheartedly welcome Advocate Anil K. Chauhan to this function. I welcome all my elders, colleagues, and dear friends, and all ladies and gentlemen who join on this virtual platform to participate in the function. I also welcome media presence. By these words, I conclude and I respectfully invite our president to deliver the presidential address. Please, Justice.
Good evening, my friends. I welcome my former Chief Justice, Justice Radhakrishnan. He is a nice person. I met him while he was in the bench, and I had the occasion to argue before him in many points of critical issues so far the concerning constitution is concerned. I found him very intelligent. I used to say amongst my friends, very intelligent judge, but a little lazy. And that he had also echoed in one of his comments that I'm a lazy judge. But it's a very, it's a good occasion for us to have interaction with him while he was on the bench, and I'm still in the bar and I have been appearing before him. This is an occasion where we would enjoy his deliberation on the occasion in the memory of our first founder president, Mr. Daniel Lathifi. Much has been said about by my secretary, therefore I'm not going to waste time on that. I would request all of you to patiently hear the deliberation of Justice Radhakrishnan and concentrate all of your ideas on the issues of parliamentary democracy and the independence of judiciary, which are two important and independent, interdependent organizations and wings. Therefore, the independence of judiciary is one of the very important aspects on which I believe Justice Radhakrishnan will definitely throw light. With these few words, without taking further time, I would be waiting to hear the deliberations of Justice Radhakrishnan to enlighten us, to enrich us. Thank you all. I would invite Justice Radhakrishnan to start delivering his speech.
You have to unmute, sir. Thottathil, Justice Thottathil is muted.
Justice Radhakrishnan will unmute yourself. Yes.
Okay. No.
Good evening to one and all. It's quite fascinating to see Mr. Bhattacharya, my good friend Mr. Surendranath, and Mr. Chauhan, whom I have not met until now, in the physical mode. We are meeting for the first time in the virtual mode. Well, I would start off by saying that a lot of deliberations are going on, but very few of the crystallized conclusions get translated into action on ground. Whether it is the deficit in the manner of selecting the judges, deficit in the manner of the constitutional watchdogs getting opportunity to scrutiny and scrutinize the continued qualitative and quantitative performance of the judicial system, adhering to expected standards of ethics and morality, which I think have to be taken as inbuilt in the constitutional system, rather than trying to say that morality and ethics have no foundation in the Constitution. I say this in the particular background of the fact that a lot of complaints have sometimes not merely cropped up, but continuing to be existing regarding various aspects in the management of the higher judiciary. This is one issue that obviously should gain the attention of all concerned, all wings of those operating the Constitution of India for the benefit of we the people of India. Judiciary and the Constitution, and judiciary under the Constitution, and judiciary for the Constitution. These are three concepts which, according to me, lie interwoven. And there are certain principles which sometimes get lost, and the adjudicators and other participants in the justice delivery mechanism lose sight of the core theories on which the Constitution stands footed in terms of the aspirations of the Indian people. We quite often talk of fundamental rights, the equality doctrine, various other aspects which have manifested itself and shown its real existence through the written judgments of the superior courts, which by and large were recognizing the existence of fundamental rights as a primary principle and as a seminal doctrine which underscores the fundamental theory of equality, on the touchstone of which alone different actions by the administrations, even by the legislative bodies, could be scrutinized. If we examine the modality of the judicial functioning, when I use the term judicial functioning, I mean not merely the courts, which primarily is conceived as a three-tier system, where we have the Supreme Court of India, the various high courts, and the district judiciary, which takes in officers of all ranks within the judges, within the districts. I would say that with massive, I'm very particularly and specifically using the word massive, very massive modality of tribunalization, that is clustering of tribunals in lieu of the regular courts. I'm not a critic of that in the complete sense of it, but at the same time, we need to ensure that by tribunalization and by reducing the scope of actual adjudication in well-trained courts, we should not be sacrificing the core principles as well as the foundation of judicial review, which is of great importance and a constitutional value which cannot be forfeited, even by the Constitution. When we started with the concept of tribunalization in India, and so many tribunals had come, with passage of time, specialized tribunals bringing in a sort of modality where you have people coming in from various walks of life, different streams being brought to preside those institutions with the necessary concomitant of personnel drawn from the sitting or former or retired judges to bring in the judicial component into it to some extent. I have my own very serious misgivings as to whether the mere concept of fast forward in terms of technology cannot be applied and should not be applied with that swiftness with which the system may sometimes move, jeopardizing the very course of justice. If we examine the concept of tribunalization and the growth of tribunalization and the manner in which it has gone through during the last maybe 2.5 decades, now it has branched out into various sectors. Let me just point out one line as an example. When the civil courts of India were, for various reasons, not coming up to the standards of the commercial activity in the nation to deliver verdicts in litigations touching commerce and financing, it was thought appropriate to bring in what is called, in its short form, the debt recovery law, or the debt recovery law which provided for the debt recovery tribunals. Of course, as many of the new legislations do have, it has got a huge title, long title. Now the debt recovery tribunals came. Now after the debt recovery tribunals were permitted to play for some time, the heaps of cases which were on the board of the debt recovery tribunals persuaded the lawmakers to think that there has to be some other alternate mode. Then came what is called the SERFACI or securitization mode. Now, insofar as mega lenders or the big lenders in the company sector are concerned, we have also tribunals, including those dealing with borrowing and lending and other commercial activities within companies and also intra-companies. This is how that sector is growing. In this process, I would sound a word of caution that if the adjudicators, with all the input they have, maybe in the field of commerce, maybe in the field of financing, maybe in the field of accounting, maybe in the field of structuring the companies, restructuring the assets, the modality of asset management, whatever. But the core principles of true justice should never get sacrificed. This is something that has to be aimed at by all institutions of judicial governance. I'm saying judicial governance because judiciary is always understood or primarily understood as institution of adjudication, decision-making, and delivery of verdicts. But now that sector has actually grown. Administration of courts by the judiciary themselves, pushing away all possible suggestions of administration of judiciary and ground level management being handed over or controlled by the top ring of the judiciary, however, through the administrative sector, has also not gained the confidence of those manning the judicial systems. This is why we have a lot of practical difficulties which the courts now have, particularly in the managerial sector. Left to myself, I would think, with whatever little I can claim as my experience, having worked in 5 high courts in India and been the Chief Justice of 4 high courts and also the acting Chief Justice of my parent high court. It is not always your capability of justice delivery or adjudication that really makes you a good administrator. Administering the judicial sector, according to me, what I've learned is a mammoth task. That is not an easy thing. It is not something which can be done as if from one table you sit and deliver your verdicts, carrying out the process of adjudication, turn your revolving chair to the next table and start doing your administrative work. It needs a complete change of the mindset. The focus, without sacrificing the core concepts of the Constitution. Administration is necessarily something very, very different from adjudication. This I can definitely underscore with the experience that I've had, obviously in my mother state or parent state, parent high court, that's the Kerala High Court, where things sometimes really move quite fast. When I was in Kerala and I could complain that Kerala is not moving fast, when I went out of Kerala, I knew that I was wrongly complaining to a large extent about Kerala. And the challenges that each state has, not merely in providing the social evolution mechanism for the people of each state, but also in the manner of providing the judicial mechanism of resolution of disputes. I can vouchsafe for the fact that the modality that I had adopted in Kerala could never have been applied in the state of Chhattisgarh, where the social pattern, the manner of life, the concepts of the common people, the concepts of the administrators are all definitely at huge variance from what I had in Kerala. The same thing happened as I moved on from Chhattisgarh to Hyderabad, where, of course, my main administrative task was to carry out the process of separating that single high court at Hyderabad to be 2 high courts, one for the state of Telangana and one for the state of Andhra Pradesh. There I learned a wonderful experience I had. I knew that inclusiveness and collective activity can bring better goods rather than trying to do it all alone. I had the committee of judges of the Common High Court helping me in all different aspects of bifurcation. I'm sure that it was just not an easy job. It was not something which you could accomplish as if you are cutting your birthday cake. It's as if you have to take care of not only the happiness of the people of the 2 states who may, for various reasons, be happy of the bifurcation, but also you have to take into account the tears of people who had worked in one station of the Common High Court, asked to segregate, and one to continue in the same station and other to move miles and miles away to a very new place where they have to plant themselves. Various options were given, various contentions and considerations had to be gone into. But ultimately, let me tell you, what really worked was the ability of the leading teams to take the people into confidence. When I say people, primarily I mean the employees, the staff, the officers, their families, their children. These things had to be cohesively considered because you're trying to plant a part of a full-grown tree. It is not as if you are carrying a sapling to the next place. There I learned this particular issue because I had also the support of the people not belonging to the judiciary, but to the administrative sector of India, particularly officers of both the governments of Telangana and Andhra Pradesh. Officers who had the administrative wisdom, the practical wisdom of administration, rather than what the judges inculcate in them as administrative wisdom, with the little administrative arena that they get as they come up the ladder in seniority in the different high courts. Coming to Calcutta, well, now that Mr. Bhattacharya is here, whatever I had tried to do there were also carried forward by ensuring that there is, if you say what is governance through democracy, I said democracy is not merely the going for elections and choosing the people to be leaders at the houses, but a collective existence, collective management can also bring in principles of democracy, though we don't go by counting the heads. But hand in hand, if you work, definitely things could happen, especially when you have states where, I will very politely say, sometimes the political climate may not be so conducive even for a Chief Justice to work. I'm sure that I've communicated what I mean by that. Coming to the larger spectrum of judiciary and the constitution as such, we always hear arguments in courts. We always hear a lot of statements by people in authority. And also we hear a lot of even debates based on the fundamental rights. In the last about 8 to 10 years, I have also started hearing some of the people, at least, start speaking about the fundamental duties of citizens, trying to strike a balance between the fundamental rights and fundamental duties. Well, left to myself, I will not go to the extent of saying that your guaranteed fundamental right is dependent upon your guarantee to the nation to live by the fundamental duties. Not always. There are fundamental rights which are of critical importance, which are of primary importance, which are of seminal importance, even when you are at fault, when you perform in conflict with the fundamental duties, which is nothing but the aspirations of the Indian people regarding your behavior and jotted down in the constitution. But there is one core theory which I had been trying to push through as something which is very important, especially when all said and done, our population is growing. When the population grows, its impact comes not merely on food, shelter, etc. It trickles down to every little sector. If you look at the number of motor cars that are plying, who are the number of families which can really afford? There are certain nations outside India, where they try to put a check on the number of vehicles that can even come to a particular identity called family. Keeping that aside, I have always tried to find out at least the judiciary and the administration taken together, getting completely focused on the principles of the Constitution, which are so crucial and fundamental for the governance of a nation, which are well scripted in Part 4, that is the Directive Principles of State Policy. Personally speaking, I am a strong votary of that fact, that part of the Constitution, very particularly because that part itself says that the principles herein are to be treated as guiding beacons of governance of this nation. I have consciously and deliberately kept away from using the words in the Constitution. At the same time, saying that this shall stand to advise all institutions of national life. I definitely would say that if there is one institution of national life treated as an institution of prime importance, it is necessarily the judiciary. So if the judiciary in its activity, not merely as adjudicators, but also as administrators of the justice delivery system, do not stand guided by the principles in the Directive Principles of State Policy, which, of course, stated by the Supreme Court, are not enforceable by themselves. It's not a question of enforceability. You are tuning to a particular constitutional culture of thinking, and your thought process gets molded into the core theories of socialism, core theories of secularism, which are embedded in the Directive Principles of State Policy, so that we can proudly say that we continue to exist as a sovereign, socialist, secular, democratic republic. These 5 words, I always would try to say to whichever group I get, please treat these 5 words as 5 legs of a brilliant angel, which can be treated as either the mother or pattern of this great nation. And don't treat it as a 5-legged monster which is waiting to eat up under the guise of the Constitution. I would borrow this principle and go into the question raised by the welcome speaker as well as the Mr. Bhattacharya on the question of accountability of the judicial mechanism, not individuals manning the judiciary, to ensure that there is a clear mechanism of superintendence of ourselves or superintendence of the judicial system itself to say that all appropriate issues are addressed, redressed, and the mechanism is cleared and kept always strong to live up to the constitutional values. Well, I heard either of them mention about the collegium system. There is a group of thinkers in our field, in the field of law, who take it that among the existing modes, collegium system could stand, subject only to certain conditions. One is transparency. The second is or rather I would say the most important is credibility. Credibility and transparency should be inbuilt, because that is the core underlying doctrine of every authority which can call itself as a judicial authority, the very concept of being a judicial authority. Therefore, there are also views that if you open up too much, you will be unnecessarily gaining criticisms which are not due. But I would say that whether an institution as an institution comes into being to audit and monitor the intake and the continued surveillance of persons who are taken into the judiciary to perform judicial acts, we have to ensure that real complaints do not go unattended, do not go with answers which would not be normally available when such complaints are raised in other equally critical and sensitive areas of governance in India. There are departments, there are sectors where, in the larger interest of the nation, in the larger interest of the administration of the nation, decisions are taken without explicitly or impliedly, or even in the so-called, I say within double inverted commas, so-called sealed cover mechanisms, disclosing the reasons for such activities in the larger interests, in the larger interest of the better administration of the nation, in the larger interest of the better administration of the administrative sector of the Indian governments, in the larger interest of administration of the states, in the larger interest of better administration of the judiciary. Obviously, these are phraseologies which do occur in activities connected with the administration of judiciary at the highest levels. Specifically, this phraseology has come to stay by and large in matters relating to transfer of judges. I thought of mentioning this when I think it was the welcome speaker who mentioned about Justice Qureshi. I'm not on the facts of any particular situation. I'm not on any particular case, or what has been done or what has not been done, or what could have been done or what may be done in the future. No. But if he sounded that there is at least something in writing by a former Chief Justice in what his biography or an autobiography, which maybe, as Mr. Bhattacharya pointed out, I'm a bit lazy in reading these sort of books. I'm more concerned about keeping myself away from putting all slush into my thought processes. But if there is some reason, forget about Justice Qureshi's case, any case for that matter, it is not as if at least somebody somewhere having due authority, including within the cover of secrecy, maintain it. Maintain secrecy. It has to be maintained in the larger national interest, in the larger interest of the territorial integrity of our nation. Certain secrets have to be kept. keep it. But when you do that, we have to underscore one cardinal principle, that is the credibility of such institutions, be it on the judicial side, be it on the administrative side, or be it in public eye. It depends upon consistency, which shall be the benchmark of performance. The consistency should be examined on the touchstone of the constitutional principles and values, which also cannot stand dancing to the tunes of changing times, to the bugles that may blow from time to time, to the beats of the drums that may keep changing from time to time. It is necessarily to be structured. Even when we go to the basic structure doctrine of the Constitution, and we try to further develop it and say that with all these nuances, we have to run the nation in such a way that the judiciary has the entitlement to be the institution of prime importance, to be protected and insulated from all sorts of onslaughts, which would be violative of the Constitution. Whether it is the pre-emergency era or the post-emergency era, if we were to concede authority in defeasance of the credibility, defeasance of the independence of the judiciary, that will be suicidal, not merely for the judiciary, but for the entire mechanism of governance of India, which in turn will be suicidal to the very concept we the people of India. Having said so, I want to add a couple of things. When we talk about judicial independence, that's a term that there's a lot of, with great respect, loud talk. Judicial independence, be it through the judgments or be it through platforms where discussions go on in such manner. Judicial independence to work without fear or favor. Quite often it is understood, even by the students of law, in the various institutions where I have had and also still have the opportunity to interact with the students. Good lot of them really go by the concept that judicial independence or independence of judiciary means it is insulating the judiciary from any sort of intrusion or the so-called onslaught by the other two wings, that's the legislative processes and the administrative sector. This is how the broad spectrum really works. I would underscore that it is time that every judicial officer carries with him, not merely on a small paper book in his pocket, but in the bottom of his heart. Every moment he's alive as a judge. Alive as a judge. I mean alive as a judge, not merely when he sits in court. So long as he is a judge, when he is alive as a judge, I would say, even after he demits office on superannuation or otherwise, he should continue to be insulated from everything as an individual judge. This individuality of a judge should be so sacrosanct that it has to be preserved, and it is only that individual who can preserve it. and every other institution of governance, every other group in the large group of judges can only motivate him, support him, empower him, and also recognize the credibility of such persons so that they stand as outstanding examples in judicial governance, adjudication, and in a judicial way of life which is expected of a judge. I say this because judicial discipline and insulating the judges and protecting the judiciary from onslaughts is not always a collective mechanism. I would say that it is high time that we should necessarily start speaking about I'm not talking about the protection of judges. I'm not talking about the manner in which you protect the judges from other litigations, etc. I am saying about the qualitative credibility which can be infused into every individual judge at whatever rank he works in the judiciary. And it is thus such judges who really make the judiciary an indefeasible, self-protected institution where intrusion from other sectors, when I say other sectors, please do not be under the impression that the only two sectors which tries to poke the nose into the judiciary is the legislative and the administrative. No. We have not in the merely the national angle, I'm talking about the world angle. We have PowerPoints, extra constitutional PowerPoints. I underscore, I use the term extra constitutional PowerPoints. No constitution of any good country like India, no constitution like India has ever recognizes any extra constitution which may be infused by such qualities or powers which are democratic on the face of the constitutional values. If I were to be asked as to how do you permit or how do you ensure that the judiciary is protected, it depends upon bringing up the judges in such a manner that collectively they will stand as a powerful soldiers who can be called as a brilliant, self-protecting judiciary which has to stand by itself. Accountability is an indefeasible component of every exercise. If the legislature, be it at any level, brings out a legislative device, brings out a piece of legislation in a manner which it infracts the Constitution, the mechanism is open. There can be judicial review. Initially understood as 4 enumerated principles or 5 enumerated principles, which with the passage of time have slowly opened up a little more. We are proceeding to better issues which can be shown to exist. The concept of colorable exercise of legislative power, fraud on powers, whatever these are, they are getting a little more understood in judicial review matters in a little more open and spreading out way with the change of times. If legislative action, legislative conduct can be subjected to scrutiny, if the performance or behavior of a person who is a member of a legislative body can be subjected to judicial scrutiny, at least after it has undergone a process which is prescribed by law, which is within the very same legislative organ. Why not data relating to the activities of the judiciary, not merely this statistics, not merely the pendency statistics, not merely what you get as the judicial data grid, but beyond that, the perception of the judiciary has to improve, and it can further improve in public eye. Not that it is bad, but it can further improve only when there is a guarantee that in situations of actually be of importance to do not a superimposing role, but such role which could be supervisory, not superimposing. And such supervisory power is not merely one which is just to find out the reason, but to find out the end result of a bad track. I do not have to explain to anybody in India. When I say anybody, two words, any body, B-O-D-Y, in India, fairly well informed about the process of impeachment we have in the Indian soil, the history of whatever efforts were taken for impeachment of judges. Where did it all go? What did happen? What could have happened? I'm not on individual cases, I'm on principles. There is also a concept which is growing that certain modalities of management of the judicial spectrum, not the inside the courts, but in the management of the judicial infrastructure through the human beings. When I use the word infrastructure and human beings, I mean the humans which form the real infrastructure. The other infrastructures are there. You need the washrooms, you need the staircase, you need the computer peripherals, and all those things is there. But according to me, for me, the basic infrastructure of a powerful judiciary is human beings with heart and soul, which is pulsating in terms of the constitutional values and nothing beyond and nothing else. But to maintain that, the first guarantee to those officers is the protection that India would ensure in case of need. No judicial officer at any level for that matter. When I say judicial officer, I mean the district judiciary. I've seen judicial officers, good lot of judicial officers, people who cannot. I'm talking to you all in English language. I've seen my officers who could not communicate even in this language. Why? The modality of governance at that part of the world, the modality of life at that part of the world, the modality of adjudication, the modality of justice delivery did not require this English language. When I was posted to Chhattisgarh, that was my first station of posting as a Chief Justice from when I was going as a Chief Justice for the first time from Kerala. I had good lot of officers thoroughly and totally committed. If at all I could say that there was something short in them, it was their ability to communicate in English. Many personalities at the higher realms of judicial administration of India attempted to also advise me that they have to start growing in English language. I had my own deeper thoughts on that issue. I still recall a week or so after I took charge of the Chhattisgarh High Court, a few officers came to me and they told me in fairly understandable, communicative English that they may be excused for not being able to put up the files in the manner in which it could be done in English language, because that High Court has also the history of putting up the files in Hindi language. I had to tell them that I am the minority. Let me very politely use very positively the word minority. I am the minority. I don't want all of you to get trained to communicate to me in English language. It is better that I try to communicate to you or understand you in the language in which you can communicate. Because I pointedly say this because when you cross different states for the purpose of administration of the judiciary, you do have these problems. Later, I went into the process of studying the history of that High Court, which can be treated as a baby or an infant or even an adult, not even an adolescent. It was hardly 12 years or 13 years after the High Court came into being that I became its Chief Justice. Then I knew that it was part of the Madhya Pradesh High Court, and it was carved out to make the Chhattisgarh High Court. And in Madhya Pradesh High Court and the Madhya Pradesh state of Madhya Pradesh, Hindi is taken as an official language in terms of the Official Languages Act. And judicial officers, not merely at the district judiciary, even the judges of the High Court could, if they wanted, deliver their verdicts in Hindi language. I'm sure that the senior members of the bar or other elders who are linked in to this program, including Mr. Bhattacharya, will recall that at one stage in Indian judiciary, when we were all at the bar, that too not at the senior level but at the junior level, there was a policy which cropped up: transfer of 1/3 judges from each High Court. The result was, in some states there were problems. In some states, it was a great opportunity because the High Courts got exposed to other materials from other states. The modality of judicial thinking, the modality of court management, everything came in. In fact, I would say that the state of Kerala and the High Court of Kerala stood benefited by at least 4 or 5 such transfers, or even 5 or 6 such transfers, of whom one later on went to be the Chief Justice of the Chhattisgarh High Court long before I had reached there. So we could get ideas flowing in from other High Courts. But how do you get over the other problems? All these can be well if the audit of performance becomes a consistent and continuing activity in the judiciary as a whole. Without meaning disrespect to any person in any part of the world, let me tell you 2 basic principles on which I have always tried to work. I'm talking from the administrative point of view. I believe, maybe to some extent, from the principles of governance in military and different forces, If the top is correct, the bottom will be correct. And merely because the top changes, either by transfer, retirement, or otherwise, the structuring and continuity of the establishment should not immediately change. This is a big problem that I've always seen. A change at the top changes the very outlook of various mechanisms going through the different institutions, not merely the primary judiciary, but also now I would say that there are secondary institutions which are like extended filaments of the primary judiciary. Justice V.R. Krishna Iyer's concept of Lok Adalats got fructified ultimately, and we have brought it forward. India has brought it forward, carried it forward. Now what we have as the Legal Services Authorities Act. We have in place National Legal Service Authority, the State Legal Service Authority, the DLSAs, the TLSCs, etc. Well, this is one set, one of those extended tentacles. Another tentacle of late is mediation as one of the alternative disputes resolution mechanisms in terms of the Code of Civil Procedure and otherwise has now been brought into place. There is a structured mechanism under the control of a branch of treated as another tributary of judicial governance. Yet another one which is now trying to branch off from the primary route of mediation is what is called the commercial arbitrations and the commercial mediations. And we have also the internationally renowned hybrid varieties called the international commercial arbitrations and the international commercial mediations, which are said to be critically important as far as international financial governance and commerce governance and management of international business world is concerned. So these are all changes which are brought in based on the need of a growing society. Let us take it so. Let us take it so. But if you don't have an audit on the basis of credibility, you're talking about statistics. I mentioned about the National Judicial Data Grid. The technique under the National Judicial Data Grid is, Chief Justice, if I press a button, on my screen will appear the number of cases disposed of by the officer at the lowest rung of the judiciary of that state under that high court in the remotest station where he will be sitting and working. This is the right royal system in which it has to work. Whether the system is physically working in that mode is again a large question or a bigger question which needs to be answered. Well, we have excuses galore. The system is hung. The data operator, data entry doesn't work. I mean, forget about it. But then this is the concept. With all that concept, you are able to monitor the statistics in terms of disposal. That is the quantitative disposal. But then the qualitative disposal. Qualitative disposal is something which the judiciary can attain only if those ordained to supervise and exercise the power of superintendence maintains a continuous audit when they are empowered to do so in terms of Article 227 of the Constitution and the High Courts. It is not merely 227 is not merely to entertain an application. That too applications in lieu of Section 115 of the Code of Civil Procedure. If you say that the eyes and ears of the judges who are controlling the institutions should continuously be active and they should have a gaze on the judicial system operating under their wings, I am sure the judiciary, the judges at the High Court level at least, and I would say even the principal sessions judge or the district judge at the district level can necessarily easily find out the qualitative performance of at least many of the people who are working in that cadre. What is the great thing that a judiciary or a court or a judge gets by sitting on a delay petition for 2 years and thereafter passing some sort of order? And that matter, if it is against the litigant, he goes to the superior court, gets it reversed sometimes, comes back again, another 2 years gone. This effective time management, if not carried, timely justice will be the greatest casualty. Timely justice, qualitative justice, and through the modalities of mediation, etc., to provide provide the support mechanism to take the emotional hit on the litigant. That's where we say, when I was a newborn at the bar, my senior used to tell me, in all cases, you will not be appearing for the decree holder. In all cases, you will not be appearing for the succeeding party. At the end of the day, when your party loses, please show that element of compassion where you show your shoulders for him to lean to, not because you are going to help him in the next stage, but for him to relax at that stage. I said this at this point of time because this mental element, according to me, is a critically important aspect which has to go into not merely the lawyers, not merely this judgment debtor's lawyer, not merely this losing litigant's advocate. It should go into the mind of the judges. It is not as if your compassion should flow when that is not due, but management of the mind of the judges to deal with people before them as human beings, to deal with them keeping away, let me very politely say, keeping away the feudal mindset, not meant against anybody, any group, not meant against any class category. This comment is not addressed on any specific issue, but I am saying I have seen this mindset is one of the greatest problems, the bottlenecks of vibrant judicial performance. Bereft of that, we should not be discussing judicial activism. If at all there should be activism. Judicial activism, according to me, is not merely trying to jump into the shoes of the legislators or the parliament and make law, or say that you do this till you make the law. Fine. Sometimes some patching up may be done, but that again is not the judicial activism sector. Every case before a judge is a case for judicial activism because he has to activate the judge in him or her. And that product which comes out is the product of judicial activism. But how are you going to instill this in every judge or judicial officer in the system? Taking the system as a whole and coming back to the question of the credibility doctrines, a lot of talk really happens that the system is bad. Fine. I don't agree that the system is really good. But when you talk, recently I had a youngster he just completed his internship with me in one of the high courts. And he said he wants to have a peep to another high court where I was then the chief justice. He came to me because these interns are actually like, chotus in the family. They run around and, they take the books and sit and study. You can note from the intern, you can identify where this chap is really going. Such an intern, a very, very, committed person. He was asking me, sir, with all this, when you go forward, where do you really say that this system is really working for the downtrodden? This is what he asked. I said, what do you mean by downtrodden? we used to very politely, I mean, there's a lot of these young boys and girls, a lot of opportunity for us to get ideas. Because it's not as if we give them ideas, we also get a lot of ideas from them. And one of those boys told me, sir, what I meant is actually not merely economic exclusion or social exclusion. Very important is exclusion from due and legitimate opportunities. When you say there is an exclusion from due and legitimate opportunities, we have also to understand there is an undue extension of opportunities in certain cases, which will be anathema to the optimum growth of any institution or establishment, including the judicial spectrum. I don't use the word system, I use a judicial spectrum. Judicial spectrum is a large spectrum where these so-called judges, the advocates, even the academia, and I say the judicial administrators, the administrative sector in the judiciary. No chief justice can run any high court. No judge can run any court without the support of the staff, without the support of the officers, without an able registry. I'm sure any great chief justice or a so-called great chief justice will be an utter failure in managing a high court. Assume the vastness of a high court like the Calcutta High Court. Mr. Bhattacharya will know the huge expanse and spreading into two circuit benches, and the various issues that can come up, not merely in judicial management. I therefore would suggest all of you to kindly consider that to stick to constitutional values and to ensure that the institution of judiciary really stands up with a consistency on the basis of constitutionally identifiable benchmarks. It is necessary that there has to be a continued audit of the performance of judicial institutions, not only in terms of quantitative output. Qualitative output is important, and equally important is the modality in which that institution deals with, and I would use the word behaves with every stakeholder, not merely the lawyers, the litigants, the witnesses, the court masters, the court officers, the peons or other substaff. If I am earning my salary, they are also earning their salary. They are doing the job that is given to them. I am doing the job that is given to me. Therefore, a collective existence leading to a harmonious exercise of judicial functions can be obtained. And when I say that there must be a continuous audit, I mean that there has to be an institution of audit, institution which ensures the audit through a mechanism which is devised by people who are capable to think and decide upon such matters, deliberate upon such matters, present views on such matters, and ultimately leave it to the lawmaking bodies to decide as to what shall be the modality. It is not as if the world is not seeing all this. If I were to use the word ombudsman, I think we have in India a legislation where Lokpal has been brought. This is the word, I think the terminology is Lokpal. And there is a Lokpal for India. And there are restrictions on the Lokpal and the Upa-Lokpals to take any other office after they hold office as Lokpal and all those things. I'm looking forward to how that institution is able to carry itself forward. Because we are looking at institutions where we can really have if you can have an audit report of the performance of every other I'm not saying that the Comptroller and Auditor General or the local fund audit, it's not financial audit alone. Financial audit is only one part of the management of governance. In judiciary, it is not I will repeatedly, I'm saying, it's not merely the quantitative output, the qualitative output. The qualitative output, along with the manner in performance, manner in dealing with the people, that is called, if you call it in the modern terminology in management, we call that as a PR relationships, public relations modality. You don't have to put your hands around the shoulder of every person and walk around, but the modality in which you interact, the modality in which you present yourself for them to deal with, the modality in which you provide a cup of water to a litigant who is unable to stand in the court, the modality in which you would provide a chair to a person to sit, the modality in which you would provide a weeping woman who has come for a family litigation, a place to sit, a place to feed her baby, a place from where she can have a cup of water, a facility to have food, a facility to have, if necessary, such facilities in the toilet, which will be a proactive support to the female folk, including the sanitary dispensers, which are indispensable components of any institutions of governance of this nature. I think we need people who think of ground realities and not merely the big values and issues. We need people. We have people. That's the whole issue. We have people. We need people. But then we need to push. But if pushing doesn't work, then how do you do? Craft and make institutions which will be treated as the points and the pushing points from where you know that your performance is going to be audited. It is not meant for X, Y, or Z. It is meant for A to Z. In one huge caption that Article 14, with the case of Article 21, underscoring all values which are inbuilt among the principles of governance, which spring not merely from the directive principles of state policy. The greatest doctrine which I had, let me just share with you in spite of the time factor, one issue that cropped up for a discussion in the National Judicial Academy in Bhopal, those days when we were regularly there, at least as resource persons or otherwise. What is the greatest value in the Constitution? What is the greatest right? What will you treat it? What will you, if you are going to rank 1, 2, 3, where do you put? Let me tell you, discussion was so heated. Everybody started on Article 14, went on to Article 21. Many went on to various other facets. Some went on to the international domain, came in through certain other provisions of the Constitution to say India is compelled to make certain laws by reason of certain international commitments. But ultimately, all of us zeroed in on one huge concept in the Constitution, which is in the preamble, that is dignity. Dignity, dignity. If every judicial officer from the bottom of his heart, if the entire judicial mechanism from the bottom of the heart is prepared to salute the beneficiary of the judicial mechanism and uphold the dignity of not one individual, but of the entire collective group, not merely of we the people of India. Indian courts actually serve to various other sectors when it comes to the international domain laws, when it comes to international transits. Therefore, if the judiciary needs an audit, or whether the judiciary needs an audit, I, for one, is completely in favor of it. Need not be that the audit is on the face of any individual. I audit my children. Both of them are married. I audit them. Where? I don't go and ask them anything, but I watch them. That watching is sufficient. Like every elder knows in this who have been linked in, everybody knows. How do you audit your child? Not because of the progress report in the schools. If they get a progress report with a mark of good behavior, I would value that more than the AAA plus which they have got in the exams. So the way in which you want an institution to function, monitoring is absolutely necessary. There is no gainsaying that we are what nobody else can be, and therefore we don't have to be audited. We don't have to be supervised. Supervision is not imposition. It is just to ensuring the beneficiary that all is well. That is all that is required. This judiciary under the Constitution, I mentioned about the tribunalization. Similarly, many things are now trickling from various sectors. All this put together, the judicial wing should necessarily carry with it the prime principle that the legislative component of governance under the Constitution and the administrative authority to control and command the administration are not to be scouted upon, but necessarily to be looked at, necessarily to be scrutinized, necessarily to be corrected in terms of the Constitution to the extent to which the Constitution provides, without assuming that the judiciary is a panacea for all ills. Thank you so much for lending your ears and also for this great invitation to me. I did not mention anything about the person in whose name this first memorial lecture is being delivered. That was a very conscious action on my part because I had reserved it till the end. I wanted to say, look at his life. Look at his life. He had all the freedom he wanted. The way from where he was born, from where he did his schooling, from where he went, through where he came to the communist way of thinking, and from there, from where all he had gone. He had that freedom. This is freedom of thought, freedom of conscience. When
Thank
you so much. Namaste.
And Chauhan?
Sir.
Yes, please.
Okay. Honorable Mr. Justice T.B. Radhakrishnan, our President Sri Vikas Ranjan Bhattacharya ji, our dynamic Secretary Sri P. Surendranath sir, and participants from all over the country, on my behalf, on behalf of EDU Center, and on behalf of our organizing committee, I express my deep thanks to all of you, sir. I share the dais with Justice Radhakrishnan in the second state conference at Bilaspur. I was with Mr. Surendranath at that time, sir. And my friends, Justice Radhakrishnan delivered a thought-provoking and heart-touching lecture covering the various facets of the subject. My friends, the country nowadays facing extreme situation since independence. The democratic space is shrinking day by day. In the background, the role of judiciary is very important. It has now two-fold challenges. First, to protect the fundamental rights, human rights of its citizens, and second, to restore the public faith in the judicial system. As Martin Luther King said, injustice anywhere is threat to justice everywhere. Judiciary has capacity to deal with such situation. The famous Raj Narayan case, Three People's case, Maneka Gandhi case, Golaknath and Keshavan Bharati are the instances where the judiciary took the stand. In present days, where the people lost faith in executive and bureaucracy, the judiciary is the last hope for them. The recent trend of sealed cover jurisprudence, as my Lord speaks about that, the delay in the important constitutional matters like the Jammu Kashmir delimitation matter, election bonds matter of social activities, activists which are lying in jail, alarming. The bulldozer, the hate politics and hate speeches is to be dealt by the judiciary. My friends, the denial of allegation of Justice Qureshi, as my earlier speaker mentioned, speaks about the prison system. The National Judicial Commission is now the need of ours. My friends, I am thankful to our General Secretary to start the lecture in the memory of our great leader. Once again, I express especially thanks for all of you to join the program. We are hopeful that future your participation in future will also encourage us. As Radhakrishnan said, we mean advocates, judiciary, and litigants. I am sure that we will change the situation. शुक्रिया, मेहरबानी। और आखिरी में मैं ताज भोपाली के शेर के साथ अपनी बात समाप्त करूंगा। मैं चाहता हूं कि निजाम में कुहन बदल डालूं। ये बात वक्त मेरे ऊपर की बात नहीं, उठो बढ़ो मेरी दुनिया के आम इंसानों, ये सबकी बात है, चार बस की। धन्यवाद, शुक्रिया, थैंक यू।
Igasti, you are online. I think he's not. He's disconnected. Thank you, sir. Very much. Thank you. Thank you. Definitely, it is captivating. Definitely. Nobody left the link. Thank you.